Welcome to this free immigration help channel. Today is March 20, 2024, and we are getting into the volume 187 of me answering your immigration related questions. So let's get straight into it. The very first common question is from Grebe Vlogger 3525. Salam, sir. I was worried about you because it's been a long time, didn't hear from you. Appreciate it. Appreciate your worrying. Really happy to see you doing well, alhamdulillah. My question is that, sir, I didn't mention travel history in my immigration visa form DS-260. And soon I'm going to get my I'm assuming immigrant visa interview. What should I do at this point, sir? Is there any choice of unlocking DS-260, or should I wait for the interview and explain the whole thing to the visa officer at the time of my interview? Please let me know. Thank you. Grebe, appreciate your concern. Thank you very much. Thank you for another comment. So it would be nice if you can correct the mistake. So I would recommend reaching out to the NVC. Just submit a public inquiry form with NVC through the Department of State website. I'm pretty sure by now you already know how to do it. And see if you can just explain the situation. Say, you missed it, whatever. Just explain why you were not able to put it in while you were filling out the DS-260. But here's the thing. Are you already documentarily qualified? Because if you are already documentarily qualified, in that case, I would not bother with trying to correct the DS-260, because most likely chances are your case has already been transferred to the US Embassy. So really, at this point, it's now US Embassy that you will be dealing with. And that question will definitely come up, so I would recommend having a good explanation, first of all, why you didn't put it in the DS-260 in the first place, your travel information. Just be honest, explain what happened. And then, of course, having documentation. It can be just, stamps in the passport showing your arrival, departure, your travel history in the passport. That should be sufficient. So if you're not documentarily quite yet with the NVC, then definitely submit the public inquiry form and see if they will be willing to unlock the DS-260 again, so that you can, correct it and then resubmit it. And if you are already documentarily qualified, then just be prepared with a good explanation for your immigrant visa interview. And good luck with that. Hopefully everything goes smooth. Keep me updated. I'd really appreciate it. And let's move on to the next comment from Joel Po 43. Is the minimum requirement gross income or net income? Great question, Joel Po. Really great question. So whenever it comes to the minimum, it's always the gross and not the net. So it's not after taxes, it's before taxes. All right. So I'm gonna open up the USCIS because I really don't remember the minimum income requirements. I think it's income. I'm gonna put guidelines, income requirement. We can just put income guidelines and it should come up for us on the USCIS website. There you go, 2024 HHS poverty guidelines for affidavit of support. And I'm pretty sure it is supposed to say somewhere here whether it is gross or not. It doesn't. Looks like it does not. Let's see. I do like to, corroborate my answers with the actual information from the official sources. In this case, USCIS. It doesn't say here, but whenever it comes to stuff like this, it is gross income. So if your tax return is showing, your income being, $45,000, 725 or more, in that case you are able to sponsor the total household size of 6 people. So if you're sponsoring, let's say, one person and your household size is already 5 people, then that's how much you need to make in order. And it is a gross income, it's not a net income. I don't see that answer here, but I'm gonna put this page in a link so that you can have that in front of you. And maybe you will able to find that if you spend a little bit time reading through it. I'm not gonna spend too much time on this right now. But let's move on to the next one from AMZ229, thank you for being a public subscriber, appreciate it. Hi sir, my priority date March 2015 under F1 category, so sons and daughters of US citizens who are over 21. Documentarily qualified was February 2023, okay, so over a year documentarily qualified. I'm from Philippines. When my visa will become current? Alright, let's take a look at the visa bulletin. The new visa bulletin just recently came out for April 2024, so since you are already documentarily qualified and we are looking for the final action dates, basically when your interview, when your immigrant visa becomes available, usually that's when the interview is scheduled, and you're from Philippines, so we're looking at this column right here, this one right here, and your F1. So right now, the priority dates that are becoming current as of April 2024 are on 1st March 2012, and your priority date is March 2015. So looks like you are exactly 3 years away from your availability of your immigrant visa. So hopefully we will see some positive movement on the F1. Keep in mind, this is a rough prediction because, you know, things can move fast, and, you know, sometimes we see the next visa bulletin and it moves, you know, 3, 4, 5 months, sometimes 6 months forward, which is great. Sometimes it doesn't move at all, sometimes it retrogresses. So that definitely right now is the time for you to stay on top of the visa bulletin. Keep checking every month on this channel. Every time the new visa bulletin comes up, I make a video specifically on it. So hopefully you will see the smooth progress on the visa bulletin. But let's move on to the next question from user WX7HJ. Thank you for being publicly subscribed. Also, hi, could you please help me with some questions? What address to put in P13 and 58 address outside the United States if I am on I-589? Okay, I-589, that's asylum application, and you're commenting on form I-130. Now in the USA and live in my country and do not live in my country any longer. And number 2, what shall I answer in P53 and 54? Was the beneficiary ever in immigration proceedings? I have just filed I-589 and it is pending. Thank you very much. Okay, so I'm assuming you are the beneficiary because you have applied for asylum, I-589, and from your comment, if I understand it correctly, if not, please do come back and clarify that for me. You have somebody, so you are the beneficiary, and somebody who's a petitioner, who is your relative, is petitioning for you, submitting that I-130, because it cannot really be the other way around, because you yourself cannot sponsor anyone, because your asylum application is still pending, so you can't really petition for anybody at the moment. So somebody is petitioning for you, you're the beneficiary, obviously you're the one working on the application and trying to fill it out. So in that situation, whenever it comes to the address, it's not going to be your address, beneficiary, but the petitioner's address. But I'm gonna go and I'm gonna open the I-130 just so that I can take a look at exactly the things that you are looking at. And just to verify again with the official government source, uscis.gov, 130. There we go, petition for alien relative. And I'm gonna open the form. And that should be P13 and 58. All right, so 13. Let's take a look. So 13, here we go. So physical address. All right. So that is, as you can see, it is a petitioner. It's information about the petitioner. So that's going to be the petitioners. So if I'm understanding correctly, if you're pending asylum, you cannot petition for anybody at the moment. So if somebody else is petitioning for you, that person who's a petitioner, their address is going to be here. Not your address, not the beneficiary's address, but the petitioner's address. Whenever it comes to beneficiary, in that section of the address, you can put the foreign address. Obviously, that's completely fine because that's what they expect from a beneficiary to be. Sometimes, in some situations, a beneficiary can be in the United States, but in a lot of situations, in fact, probably in most situations, beneficiaries are outside of the United States. So you can put the foreign address. Okay, now you had another question regarding P53 and P54. So let's go to that. And you already told me what it is. Let's see, it's about the immigration proceedings. 53, 54, additional, what's it? So, now this is about the beneficiary. And as I understand correctly, you are the beneficiary and you have an immigration proceeding currently happening. And that's the application for asylum, your I-589. So in your situation, if I'm understanding your situation correctly, it will be the answer yes. And if you answer yes, select the type of proceedings and provide the location and date of the proceedings. So in your situation, it's going to be removal, recession, exclusion, deportation. It's going to be either exclusion or other judicial proceeding. But honestly, what I would do for this, if you will scroll all the way down, this form has a section for the additional information. So in the additional information, I would put the page number, part number, item number, and that would be, let's see, page number 8, part number, never mind, not this, let's scroll all the way up, there you go. It's going to be page number 7, part number 4, and then item number 53, and in the additional comments, you can actually put your asylum application information. So you can put the date when it was submitted, that it is still pending, you can say, and you can put your alien registration number as well, that you should have received already. Well, if you have received it, then put it in. If you haven't received it, then obviously don't worry about it. But I hope I understand the information you provided correctly. If not, please don't hesitate to come back and let me know and clarify it, and I will be able to get back to it and give you additional information. So let's move on to the next one. It's a thanks from CIC Jake Van Del G Myers. You're very welcome. Moving further to Stanis Baratheon 5930 actually got fired because of this ADP nonsense, pure discrimination. So that's the I-9 employment eligibility verification. Yes, so I know a lot of people miss it. A lot of people miss it. A lot of employers, they themselves don't realize that you do need to have I-9 employment eligibility verification these days. And yeah, sometimes they do these checks, especially with the bigger companies. They go through these checks, and if they find that the employee does not have an I-9, it is quite ridiculous. I completely agree with you. It is quite ridiculous, but unfortunately, that's the way it is. Dealing with the bureaucracy, dealing with the paperwork. It's one of the reasons why I started this channel. To help people who, to avoid this kind of stuff. Okay, let's move on to the next one from Ricarda Tipman. I am still waiting for the replacement green card since October 2022. Wow, so you've been waiting for quite a long time. So you've applied for a replacement card, and you've been waiting now for like a year and a half. And what if I want to travel and the card is not arriving before the 24 months are experiencing from the letter? Oh, so they told you that you have to wait 24 months. Wow, I guess they're experiencing some huge delays. I didn't realize how bad it is with the replacement green cards, which is really weird because, it's a replacement green card. So you're already permanent resident. All they need to do is just send you an updated card. I really have no idea why it's taking that long. It's really strange. And then they brag about, processing all the cases so fast and how much they were able to process, and just to print a card, it takes 2 years. Strange. How do I obtain a ADIT stamp? Thank you. Okay, so one of the options that you have, well, first of all, if you have already applied for a replacement card, because you are already a permanent resident, and because you already applied for a permanent resident card, and you do have the paperwork showing that your green card, replacement green card application is pending, technically, you should be able to travel just with that, because since you already applied, since you're living here, you're maintaining your residence, there is absolutely no reason for anybody in the airport and the border protection when you're coming back into the country to give you any problems and say, oh, you did not maintain your residence, or you did not renew your green card on time, or any of those, little things that they can catch on to give you problems. Technically, if you want to be on the safe side, you can apply for the advanced parole using the advanced parole application, which is the same application as the travel document, as a refugee travel document. And I'm gonna paste the form into this so that you have it in front of you and you can read through it. Let me see. I'm pretty sure it was I-131, but my numbers are always all over the place. There you go, application for travel document. There it is. So it's an application for travel document. With the same application, you're applying for refugee travel document, you're applying for advanced parole. You can do it if you want to be on extra safe side. Technically, you don't have to. If you're traveling, just have your green card that is already expired. I don't think as a part of application, I don't think they require it anymore to send that old green card. But if they do, I'm assuming you have a copy of your original green card, your permanent residence card, have the response, the receipt notice that they have sent you after you submitted your application for the replacement permanent resident card, and technically you should be sufficient. But again, it's not a bad thing to be on the safe side. Yes, you are spending some extra money, quite a lot of money. It's not a cheap application, this re-entry permit, but if you want to be on extra safe side, you can definitely do that. So I'm gonna put the response here, and I put the link so that you have this one as well. All right, so let's move on to the next one. From user BS2E08UU to, oh hello, my auntie, my mother as a primary beneficiary had filed and I was derivative. It's been 18 years and now the file is current. Can I file CSPA forms now and still be eligible at the age of 31? Thank you. Okay, so whenever it comes to CSPA, what it allows you to do, and man, it's been 18 years you've been waiting. Here's the problem with the CSPA. The biggest problem with the CSPA is that it only applies to the time that your original, well, you're in your, you know, in your situation, it's your mother's your primary beneficiary. So her application for you, right? She's a primary beneficiary. So you're the petitioner, I'm assuming, or auntie. No, your auntie. So your aunt is primary petitioner. It's a petitioner, and then your mother is the primary beneficiary. So it is a sister, it's the siblings. Okay, that's why you're waiting for so long. The problem is that whenever it comes to the 4 family preference categories, unless you are an immediate relative, but everybody else in the 4 family preference categories, CSPA only applies for the time that the petitioner was pending with USCIS. And most of the times it is really not that long. In most of the situations it can be a year, couple of years. Whenever it comes to the siblings, it's a bit longer. It can be 3-4 years, but still in most of the situations that time frame is just not enough to subtract. So in your situation, because it is the age of 31 right now, in that situation, you would have to have that petition pending with USCIS for 10 years or more, so that you could subtract it from that age 31 and go below 21. In that situation, yes, you do fall under CSPA, and you really don't need to file anything extra. You know, the NVC, the U.S. Embassy, they will keep. You know, it's going to be under the same. You know what? Now that I'm thinking about it, because it sounds like it's a sibling applying for a sibling. Is that a sibling? Am I understanding your comment correctly, or am I confusing something? So you say, my auntie, your aunt, and your mother is a primary beneficiary. So your aunt is a petitioner. Oh, you were the derivative. Okay, there you go. So you were the derivative. It's been 18 years now. The file is current. Yes, so now the file is cursed. So it's been, and you're 31 years old. Sorry, it's too early for me. So you are 31 years old now, and the file has been pending for 18 years. So take a look at how long the original I-130 application that was filed by your aunt was pending with USCIS. Not how long, you've been waiting for the immigrant visa become available. Well, in your situation, your mom, not how long she was waiting for the visa, but how long the USCIS I-130 application was pending with USCIS, sorry. If it is more than 10 years, then yes, you definitely will be eligible as a derivative beneficiary under the CSPA. But if it is less than 10 years, unfortunately not, because that's really what the CSPA applies to. So I'm sorry for the confusion in my answer initially, but I hope it makes sense. If it doesn't, please come back and let me know, and I'll try to. I know it's this is pretty confusing. I wish they just did it in general for the full length of how long the petition is pending with USCIS, how long it takes to become documentarily qualified, how long it takes for the immigrant visa becomes available. I think that would only be fair. Unfortunately, it's not the case. So for a lot of people, especially in the categories where people wait quite a long time for the availability of an immigrant visa, unfortunately the CSPA just doesn't do anything. Okay, let's move on to the next one from JP. Great advice. Thank you. You're very welcome. Glad you found it helpful. Moving further to Emesium Kingsley 552. Hello, sir. My name is Kingsley. I always bring my questions to you, sir. It's still about me and my two siblings. We're from Nigeria, F1 categories. My two siblings has been documentarily qualified since 2022. Priority date February 14th, 2014. What should be the problem? Because they have not received immigration letter, I'm assuming for the immigration visa interview. Mine is May 4th, 2015. Okay, so you're a little later. Priority date, also F1. So Nigeria is all chargeability area. Let's take a look, see what's going on. Again, since they were already documentarily qualified, let's see what's going on for the all chargeability for the F1. Looks like the priority date that becomes, the immigrant visa becomes available for is on 8th February 2015. And their priority date is February 14, 2014. Okay, so it's been current for almost a year now. For a whole year it's been current already. In your situation, you do have a little bit of time to wait, because right now it's February 2015. Well, on the April 2024 visa bulletin right now, the priority date that is becoming current is February 2015, and you are in May 2015, which you are pretty close. You're about, couple months away. But in the situation of your two siblings, I would definitely recommend reaching out, and I'm pretty sure I already recommended that, but if you can, this is the two things that you can do. One, you can submit the public inquiry form with the NVC and see, hey, I wanted to follow up. This case was already documentarily qualified, and the immigrant visa has been current. The priority date has been current according to the current visa bulletin for over a year now. So just wanted to follow up. And also I would recommend reaching out to the US Embassy in Nigeria and seeing, I'm going to put the link for it, US Embassy, and seeing if they can potentially answer the question. I'm assuming it has something to do with the embassy in Nigeria, because that's most of the times, because once your immigrant visa is available, now it is all, the ball is in the court of US Embassy. It's up to them to schedule the interview. So I'm assuming maybe they have their schedule booked, and that's why they're not able to schedule the interview yet. But it's worth a shot giving them a call and following up. Be professional, be polite, as I always recommend to everyone. And if they don't answer, if they don't tell you, if they say, hey, we can't give you that information, don't be upset. A lot of times they don't, but it is worth a shot. There's also another thing that you can do is your siblings can submit an expedited request. I do have a video on this channel on how to submit the expedited request with the NVC, and the expedited request works directly whenever it comes to scheduling the interview. So you already have to be documentarily qualified, which they already are, which is great, and the immigrant visas have to be available, which it is in their case. So they definitely can submit that expedited request. Of course, they have to have a good reason why they're submitting the expedited request, but whenever it comes to stuff like this, in most of the situations, there is a good reason to expedite, because you can say, hey, I've been waiting for this long, it's my family member, I need to see my family member, so far, so forth. Again, sometimes they approve those, sometimes they don't, but it's worth consideration. So let me post this link for this. And we're gonna move on to the next one from Jale Purmoazen. I'm filing I-824 for my brother and I know it will take a long time for him to get visa. Do I need to pay filing fee once I file the form? Can I pay for the fee when he will get his visa? 10 years from now. Unfortunately not. Whenever it comes to the applications, you do submit a fee with the applications before your application can be can start processing. One thing that you can take a look at if it's a problematic for you to make a payment is you can take a look at the fee waiver. I do have the information on how to apply for that fee waiver, and basically you submit the fee waiver together with your application, and if the fee waiver is approved, USCIS, they waive that application fee that they charge you for. So you can take a look at that. I believe it is a form 920. Let me find it, and I'm gonna paste the thing into my response. I'll just put fee waiver 912. There you go. So I'm gonna paste this link, and I do have the video on the channel on how to fill out this form and how to submit it together with the application. Pretty straightforward process, but that's the option that you have. But as far as if you don't qualify for it, yeah, you do have to pay together with the application. All right, let's move on to the next one from Alessandro1983. Appreciate you taking the time to do this for us. Thank you. I'm glad this is helpful. Moving further to the next one from EH says 19. My brother currently holds a priority date of June 6, 2020 under the F2A category and has been documentarily qualified since November 19, 2022. Awesome. He is from the Philippines. However, he recently turned 21 on February 14, 2024. I'm concerned that his age may impact his eligibility for the interview or potentially cause him to age out of the process. Could you please clarify how his age might affect his immigration status and what steps can be taken to address this issue? Your guidance on this matter would be greatly appreciated as we navigate through this critical phase of the application process. Thank you for your urgent attention to this matter. Okay, so hopefully your brother can definitely fall under CSPA. So as I was explaining to the previous commenter concerned about the CSPA, let's take a look. Here's the thing. There's a lot more chance to qualify for the CSPA under categories like F2A. Why? Because F2A categories, they take a lot faster to the immigrant visa to become available. So the USCIS application I-130 is processed quickly, yes. So you don't really get a lot of that time that you can subtract from the current age. But at the same time, the immigrant visa becomes available faster. So let's take a look at the Visa Bulletin, see approximately what it looks like. So it is F2A and it's for Philippines. Is it for Philippines? Philippines, yes. Okay, so right now we are looking. So immigrant visa is becoming available for people. Okay, so it's current. It is current with what we have for all chargeability, which is definitely great news. So September 8th, 2020. All right. And your brother's priority date is June 6, 2020. Okay, that's good. So that means that your brother's visa is definitely available already. So the only thing you're waiting for is the interview to be scheduled. So I would definitely recommend as soon as possible, do it today, as soon as you watch this video, for your brother to submit the expedited request with the NVC. Because like I said earlier to, I think who I was answering regarding the expedited request, the expedited request literally only helps, I cannot think of any other situation but the situation like in your case, because your brother is already documentarily qualified, your brother already has the immigrant visa available, your brother is current, the priority date of your brother is current on the visa bulletin, and there is a really important reason to expedite the case for your brother, because he might age out of the CSPA. Now, the way to calculate your CSPA, just so that you could, again, and I'm gonna go back just because it really is, you know, it's pretty confusing. It gets pretty confusing. So take a look at so priority date is when the I-130 was received, right? So June 6, 2020. Now, the next date you need to take a look at is when the I-130 was approved with USCIS. That's the approval from USCIS. It doesn't have to do with NVC. It doesn't have to do with documentary qualification. It is literally just within USCIS. The day they received it, the day they approved it. Let's say between the receipt date and the approval date, there is a year. That's the time that you can subtract from your brother's current age or the age on the day of the interview scheduled. And if it is less than 21, then your brother does qualify under the CSPA still as a child. Hopefully that makes sense. I'm glad you posted your comments, so I had another opportunity to explain the CSPA, because it does, you see, I don't know why they made it this way. It really doesn't make a lot of sense why you can subtract the USCIS, amount of time the application was pending, but not the amount of time it took to become documentarily qualified with NVC, and not the amount of time it took, to wait for the immigrant visa to become available. From what you said, it sounds like your brother does qualify under CSPA, but again, I would take a look at those dates, and I would definitely not just sit and wait for the interview, because, you see in some situations, it might take them a year, 2 years, 3 years, depending on how busy the U.S. Embassy is in your situation in Philippines. And in a lot of cases, especially in F2A cases, USCIS does not take that long to process the application. So take a look at the dates, determine for sure how long that period was, subtract it from your brother's, make sure he falls under CSPA for now, and see how much more time you have. Because let's say, your brother turned 21 just now, February 14, 2024. So he is 21 years, and my math is horrendous, and like 2 months. So he's about 2 months over 21. So if the application was pending with USCIS for a year, your brother still has another 10 months in his pocket before the interview is scheduled. So yeah, submit that expedited request with the NVC. I do have a video on this channel on how to do that, and tell them we need this done ASAP because my brother is aging out, and he's documentarily qualified, his immigrant visa is already available. We just want to get it, and that's one of the reasons that they do consider as a valid reason. So I don't think you should have any problems getting that expedited request reviewed and approved pretty quickly. So hopefully everyone found the answers helpful. If you have any follow-up questions, don't hesitate to ask them in the comments below, and I'll try to stay more consistent. I had to take some time off for a while. I had a few things to take care of, but I'll try to be more consistent with these videos. So I appreciate everyone watching, everyone subscribing. God bless, and I will see you all in the next video.